shareholder with Denton, Sturm, Jones, Pinniger here in Salt Lake City. I've been doing benefits. In fact, I counted this up. I started during Bush 1. I missed the Reagan years by about 4 months. So I'm in my, I think, 6th presidential administration, 3 Democrats, 3 Republicans. I mention that because occasionally I might make what you consider to be political commentary about some of the things that the Department of Labor, the IRS promulgates. Not a political statement. It's just that I represent employers, and when the government mandates that you do something that I think imposes costs and risks on an employer without justification, I'll say that's a stupid idea. It's not meant to be a political statement on the current administration. There have been a lot of changes lately. If you can imagine, President Trump's worldview is a lot different than President Biden's worldview. The people that President Trump appointed to run agencies like the Department of Labor had a different worldview than the people that President Biden appoints to run those agencies. And so in the last couple of years, we've had this change of how it used to be to how it's going to be. And again, this is my 6th administration. I can tell you that happens both ways. Pendulums swing back and forth. What was out of fashion becomes in fashion. My wife teases me about the clothes I'm wearing. I've had so long that they've come back into fashion now. So I just mentioned that as a comment that if I say something is stupid, that's not meant to be political commentary. It just means that I think employers have better things to spend their time and money on than doing something that the government, somebody the government thought would be a good idea. First thing I want to talk about are deadlines. And Diane mentioned a couple of these. I'm going to mention just 2. The first one is if you have a retirement plan, you needed to have that plan restated no later than July 31st of this year. The restatement window opened effectively about a year before that. If you haven't gotten a brand new, not just an amendment, but an entirely new plan document in that window, you need to reach out to your TPA and find out why. If you didn't sign a restated plan document in that window, your plan's no longer qualified, which is not a good place to be. You can fix that, but you want to make sure that you verify that your document is in good standing currently right now. The second thing I want to talk about are discretionary amendments. A discretionary amendment is one that the government does not mandate. So for example, if you just changed your eligibility criteria or added a matching contribution, plan document has to be amended no later than the end of the year in which that occurred for that to be timely. Third change is, Diane mentioned these briefly, the Secure Act and CARE Act changes. How it works is, think about this, Congress is meeting today. They could pass a new law like Secure 2.0 today. That could be effective today. Well, your document is now out of date. And the regulators, particularly the IRS, that cares a lot more about the form of your plan document, they realize that it's not realistic to ask employers to amend their plan documents in real time. That's really expensive, hard to do. And so they give us what's called a remedial amendment period, where you're operating your plan one way, but the document says something else. And the Secure CARES Act that were passed a couple of years ago, their remedial amendment period was going to expire at the end of this year. As Diane mentioned, we now have until the end of 2025. Now, quick question, does it make sense to wait until 2025 to amend your plan document for things you're administering now? I don't like that idea, because if you call me with a question, the first thing I will always ask is, what does your plan document say? And you should be training your people that run your plans to read that document so that they know what it says. And if the document says do A, B, C, but the law has changed and it says no, do D, E, F, then you have problems. And so you have a deadline that's out further, but it might make sense to, for administrative purposes and training purposes, to go ahead and amend now anyway, even though that's not required. The other issue is if you're administering plan, normally what triggers an SPD update is a restatement or an amendment, right? Your document provider will kick out the new plan document language and a new updated SPD. You know, they have software that does all that for them typically. Well, if you don't amend or update your plan, your SPD is out of date, right? It's telling your participants, this is how the plan works when it doesn't work that way anymore. So again, just maybe something to think about is, do you really want to wait until 2025 to get a new SPD out to your participants explaining what the changes in the law have been that are now in effect? The second type of change I want to talk about is shift out of retirement plan land for a minute over into welfare plan land, health and the non-retirement benefits. The Consolidated Appropriations Act also made changes to primarily cafeteria and flex spending plans. The deadline for amending those plans is December 31, 2022. What sort of changes did they make? You might remember, again, Diane mentioned some of the COVID changes. The CAA was basically a COVID pandemic relief act. It allowed you to carry over unspent flexible spending account balances. You could extend the grace period for 12 months. We broadened the definition of medical expenses for menstrual products. You could even make or provide dependent care to 14-year-olds, and added another year. None of those were mandatory. Those were all optional. But if you implemented any of those, again, you have an operational effect on your plan that isn't represented in your document. You can't do that. And so by the end of the year, you need to make sure your cafeteria plan and flex spending plan documents are amended to reflect any of these optional COVID-related changes that occurred primarily during 2020 and 2021. The one thing I didn't mention is that for 2023, the Biden administration is now allowing participants to make mid-year changes to their health insurance cafeteria plan, health insurance enrollment, if they want to drop out to get exchange coverage. Does anybody know what the family glitch is? When Obamacare was adopted, there was an affordability context. Remember, we were all promised it was going to be affordable healthcare coverage. There's a test for that. The test is we take the employee-only premium and compare that to that employee's household income. And if it's below currently 9.69% or 9.12% next year, that's deemed to be affordable. So let's say for an employee, the affordability amount is $500 a month. That's what the employer charges the employee, and that's affordable under that test. Well, let's say that the family coverage for that person is $2,500 a month. That would not be affordable. Well, the test is only employee only, so it doesn't matter. That's affordable coverage. The consequence of having affordable coverage is that employee and any dependent of that employee cannot get subsidized insurance on the exchange. That's the family glitch, because that employee may not be able to afford family coverage through the employer's plan because there's no subsidy for family coverage. It's not required to be. And some employers do that. They say, we'll give you the affordable employee-only rate, but you're paying 100% of the family cost. And again, for a lot of employees, that's a deal breaker. The Biden administration has changed the Affordable Care Act rules to say, beginning in 2023, we will allow a participant to opt out of mid-year without a life change event, out of the cafeteria plan, and enroll on the exchange. Because if they opt out of your health insurance coverage, we're gonna deem that to be a no offer of coverage, and therefore they get subsidized coverage on the exchange, which may be a lot less. So again, if that's of interest to you, you need to make sure that your plan is amended to allow for those sort of mid-year changes that would allow participants to drop out of your coverage and go onto the exchange to get subsidized coverage.
Do you have to do that, or is that optional?
No, optional. Don't have to do that. Mixed. And by the way, ask as we go along, if we finish early, to honor our Ask the Lawyer event, we'll give you a sample of that today. We can play Stump the John at the end of the show. The only rule is you only get 30 seconds. If you can't ask a question in less than 30 seconds, it's too complex. Just gonna have to talk to me later about that. But if you want to ask me anything that I don't talk about, we'll happy to entertain that. Okay, a couple of things on the retirement plan investment issues. The big issue right now is ESG, environmental, social, and governance. Those are non-financial factors that might be used in making investment decisions. The idea here is, are there factors beyond money-related factors that make sense for analyzing a company for investment potential? So for example, I work with a lot of employers who have primarily younger employees who say, I don't want my money going into mutual funds that invest in gun manufacturers or tobacco producers or oil companies, because those people generate products that I think are detrimental to the quality of life here on Earth. I don't want my money going into support things that I don't support. And so there's been some participant demand for, can we change the investment options to reflect things that have higher environmental, social, or governance factors. Governance factors are things like how diverse is the company's board of directors, how diverse is their workforce, what sort of support do they give pregnant, mothers, what sort of leave options do pregnant, women get, et cetera. There are ratings you can get that are intended to reward companies that do those sort of things, that are environmentally conscious, that don't burn fossil fuels, that provide benefits to their employees. Everybody earns at least $20 an hour. The multiple between the lowest paid employee and the highest paid CEO is, not more than 3x or whatever the numbers are. The question is, well, in qualified plan environments where we have ERISA, what does ERISA say about what non-financial factors or collateral benefits might be considered by a fiduciary who's deciding what options am I going to allow the participants to invest in? The original regulations that answered that question were drafted in 1979. I'm looking around like half of you weren't even around when those rules were made. And I will tell you too, 401k plans didn't exist in 1979. There wasn't a code section 401k that created those plans in 1979. That was the pension plan era. Everybody dumped it, the employer dumped all the money in this big bucket and then paid people out beginning at age 65 for the rest of their life. It was just a different world. And so believe it or not, those 1979 rules don't tell us anything about whether it's appropriate to have ESG type factors in our investment screening criteria. What does ERISA say? ERISA was drafted in 1974, even older, and surprisingly, it doesn't address that directly either, but it does tell us three things about investment decision-making processes. The first is the fiduciary has a duty of loyalty, and I'm quoting the statute here, that basically means you have to make a decision as a fiduciary that is for the exclusive purpose of providing benefits to employees or defraying reasonable expenses of administering the plan. Those are the only two things you can consider. For example, if that fiduciary is a company employee, company cost, that's not a consideration. Only two things you can think about. Does it benefit the participant and does it defray reasonable expenses? If the answer to both of those is yes, you're fulfilling your duty of loyalty. The duty of prudence is we're going to compare your conduct to somebody else's conduct. And the person we're going to compare your conduct to is what it says is somebody who has the care, skill, prudence, and diligence under the circumstances that a prudent man acting in a same capacity and familiar with such matters would do. Any of you watch crime TV shows? Yeah, I like to watch crime TV shows because I like shouting at the TV. And I shout at the TV that, hey, that's hearsay. You can't do that. No, you can't do that. The rules don't allow. They're condensing. Have you ever noticed how a crime can be committed and solved in 60 minutes on TV? Well, they make a lot of shortcuts to make that happen. Not how it works in the real world. Here, and the reason I ask that is you might hear about the reasonable man. A lot of times conduct is compared to what would a reasonable person do in those situations. And if you do something that a reasonable person would not do, by definition, that means your actions were unreasonable and you might be held responsible for that. Here, do you notice how it's not comparing you to a reasonable person? It's comparing you to a prudent person who is an expert in the things that we're going to compare you to. It's a prudent expert test, very high standard here. Last thing is duty to diversify. You do have a duty to diversify assets to prevent the risk of large losses. That means, for example, offering one investment option, probably not going to cut it because you can't diversify out of that. You want to give people a menu of options with different risk factors so that we can avoid, again, the risk of large losses. For example, bond funds versus stock funds, they perform differently. And there's a reason why those are usually in the plans, because they allow this diversification of risk. Well, there has been sub-regulatory guidance from the Department of Labor about this going back decades. It's administration specific, typically. where Republican administrations tend to view ESG factors less favorably than Democratic administrations view them as. Going back to recent history, in 2020, after the election, but before Biden took office, the Trump administration released regulations that said you can only make investment decisions regarding ERISA plan assets based solely on pecuniary factors, i.e., those things that have a material impact on risk or return, nothing else. They did provide for a tiebreaker test, which said if you have two investment options that have identical risk and reward characteristics, then you can use ESG as a tiebreaker. Well, it's impossible to have two investments that have identical risk and reward factors unless they're identical investments. There's no other way to do that. And so effectively, that meant that there was never an opportunity to use ESG factors. They also imposed limitations on the qualified default investment you could use to basically say that could never be an ESG option. And I don't know what were they saying that, well, because the participant didn't elect into that, we want to impose a higher standard there. Don't know what the thinking was, but they prohibited that. Well, again, a few months after taking office, the Biden administration, not surprisingly, said, we don't like that rule. And so they released proposed regulations that just got finalized a couple of weeks ago that made a lot of changes. First one is that although they acknowledge that risk and return analysis is still appropriate, they wanted to replace that pecuniary factors test that said, well, those are the only factors, to say, well, it's not that simple. I'm going to read something here in just a second. And I'll give you an example of that. This chart in the lower right corner, I know it's kind of small. That represents the number of electronic vehicles sold in the United States. What do you notice about that chart? Increasing and increasing at a higher rate. The slope is getting steeper over time, meaning that every year we're selling more electric vehicles than we did the year before. If you're the CEO at General Motors or Ford or Toyota, and you see this chart, is there something that worries you about that? If you're making gas-powered vehicles and you're looking at this, are you worried? If you're not worried, are you saying, wow, we've sold a couple of million electronic vehicles last year? How many of those did we sell? We're not making any, if I'm the CEO of a car manufacturing company, I'm looking at this going, there's an opportunity here. And in fact, it's not only an opportunity, it's a threat. If I'm not in on this, what's that going to look like in 2030, 2040, or 2050? At some point, I think it's prudent for me to start thinking about maybe we should get in the electric car market. Maybe we should have a product that's going to capture some of that money being spent on those vehicles instead of the gas-powered ones we're making. Is that ESG analysis, or is that just being a doing prudent financial analysis? I don't know where those lines are. The Biden regulation specifically said in some situations, ESG analysis might be appropriate. Why? Not because of the environmental factors, but because of the business factors. You don't want to be Blockbuster Video these days. Okay, technology came and overtook them, and they don't exist anymore. There actually is one Blockbuster Video store left in Bend, Oregon, not far from where I grew up, still doing just fine. They say that the people like coming in, and it's a community. Hey, anybody know a good right? Oh, I just watched one here. They like it's like the coffee shop version of a video store. In any event, they allow you to consider things like, if you're a car manufacturer, it makes sense to think about what otherwise might be considered an ESG issue, because your investment money might be at risk if management is not responding to those sort of external pressures. The tiebreaker test is broader and easier. Again, they're trying to make it easier to use those sort of factors. QDIAs can use ESG factor. In fact, they use the same test as any of their investment option. The other thing is the Trump administration said, we don't want plan fiduciaries doing proxy voting. If you're a shareholder, you get to vote the company every year. You get to tell the company what to do. The Trump administration said, we don't think it's appropriate for some office manager of a plumbing company to be voting on a complex corporate law issue. The Biden administration doesn't take that position, says in some cases it should be prudent to vote for or against because it may affect your participants. So you have to do some analysis about whether you're going to abstain or if you're going to vote, how you're going to vote. Those regulations, by the way, are they're in effect now. Got finalized a couple weeks ago. They will be challenged. They may have already been, and I just haven't noticed. They will be challenged by people that will fight those. Who knows how that will turn out. The other investment option thing I want to talk about is quick survey. Do any of you have coworkers who have asked about putting Bitcoin in your plan? Okay. That's becoming a thing. And Fidelity, one of the largest retirement plan service providers in the country, recently said, we're going to offer a Bitcoin investment opportunity on our platform, meaning any plan in the country who signs up with Fidelity could put a Bitcoin investment option in their 401k plan. Within days of that announcement, the Department of Labor released what they call a compliance allowance, a compliance announcement. Do you think those two things were related? Let me read you what the Department of Labor said about Fidelity's action. They first noted that if you're a plan fiduciary under ERISA, your duties are the highest known under the law, which is quoting a Supreme Court statement from the early 80s when ERISA was still new. They then reminded fiduciaries that anyone who breaches those duties is personally liable out of your own pocket for any losses to the plan resulting from that breach. As a result, a fiduciary's consideration of whether to include a crypto investment is subject to that high standard. The DOL then cited what was in a recent Supreme Court case, Hughes versus Northwestern University, when it noted, quote, even in a defined contribution plan where participants choose their investments, plan fiduciaries are required to conduct their own independent evaluation to determine which investments may be prudently included in a plan's menu of options. Meaning that you have personal liability for putting that fund in and keeping it in, just like you would any other investment option. They then listed several concerns. I have 8 here that they said, these are reasons why we have concerns about crypto. Some of them are particularly relevant about it's just lines of code. Crypto is basically a computer program. It can be lost simply by forgetting your password to an account. Wallets are vulnerable to hackers and theft. Any of you have been following the FTX crypto exchange news? Yeah, that was one of the largest crypto exchanges in the world. That's how you exchange your real money for the fake crypto money. And FTX is now missing billions of dollars because the CEO, it appears, was taking money out of participant accounts and putting it into a hedge fund that lost money. That's what it appears to be. And there's no, this crypto is not regulated. And so there's not the FDIC that's going to step up and make people whole, or, it's just, you're out of luck, pretty much. They then said this is the money quote. Quote, based on these and other concerns, the Department of Labor expects to conduct an investigative program aimed at plans. I love that word, aimed at plans that offer participant investments in cryptocurrencies and related products, and to take appropriate action to protect the interests of plan participants and beneficiaries with respect to those investments. The plan fiduciary is responsible for overseeing such investment options or allowing such investments through brokerage windows should expect to be questioned about how they can square their actions with their duties of prudence and loyalty in light of the risks described above, end quote. Any uncertainty about where the Department of Labor is on crypto investments now? Now, I can't tell you not to do that. It's just, I think maybe it's my age, but I like nothing happening in my life. Surprises usually mean something expensive is about to happen. And I've learned that the best days of my life are when I get to come home and I'm asked, what happened today at work? And I say, absolutely nothing. That I'm a lot happier and more interactive with those I care about. there might be other people who jump off cliffs and live a thrill-seeking life that they constantly need the adrenaline coursing through their veins as they feel like their life is being threatened. If you're plan fiduciary in that latter camp, then go ahead and put crypto in your plan, because you're going to have all the excitement you want from the Department of Labor. One other thing I'll just mention, the scary part about this for me is not so much crypto. The scary part is that language where they said the fiduciary is responsible for overseeing such investment options or allowing such investments through brokerage windows should be expected to be questioned about allowing that investment option. That was the first time ever the Department of Labor had said an investment option available through a brokerage window is now a fiduciary thing. Before that, they'd said the decision to offer or not offer a brokerage window is a fiduciary decision, but what's in the window, we don't care about. Now the Department of Labor appears to be saying, you, the fiduciary, are responsible for what investment options are available through a brokerage window. And think about what's available through a brokerage window. Anything. Was that just careless drafting? Were they aimed at, well, was the point they were trying to make, well, we don't care whether you're offering it as a core platform option or as a brokerage window option. We don't think crypto belongs in your plan. Or was it, no, we think our thinking has evolved and brokerage window investments can now be a fiduciary risk item for a plan fiduciary. Don't know the answer to that question. The other one that they released too is, this is much less common. Nobody is out there advocating for investing in private equity hedge funds, but there are some employers who have said, look, we want to have the same investment options in our 401k plan that we do in our pension plan. Makes it easier for us. Less monitoring, we don't have we can do that more inexpensively. And the Department of Labor has published guidance about what that meant. And the short answer is, yeah, we'll allow that. But they pointed out how hedge funds are tremendously sophisticated investments. They require a high level of investment education to understand how they work. And they pointed out that sort of expertise and experience is not available at most employers. Again, picking on my plumbing friends, the plumbing company with 20 employees, an office manager who's running the plan, and a bunch of blue-collar plumbers, the Department of Labor doesn't think those people really are going to understand what a hedge fund is, that there are risk factors there that just are not going to be articulated for those people. And so they're saying, you have to evaluate that. Compare your people to the investment options you're going to be offering for that to work. And so again, think about that carefully. Related to those things, the fiduciary rule, if you've been around benefit plans since 2016, you know that we had a rule, it went to court, it got struck down, they imposed a new rule, which went to court, got struck down. This has been a fight going on for the last maybe 10 years or so. Where are we now? The Department of Labor any day is about to release what I'm going to call Fiduciary Rule 3.0. That's going to tell us what duties the plan administrators have regarding investment options and how investment advisors factor into those roles. I'm not going to talk too much about that because that doesn't affect you directly. It just pay attention if you have newsletters that talk about the fiduciary rule, like I expect that to happen before the end of the year. You'll want to understand what that's going to change from what the rules are now. Again, this might be a change from Trump era definitions to Biden definitions, which will again look different. I don't know how. There's been a lot of speculation about what that's going to look like. Nobody has seen a draft copy, so we don't know, but expect that any day. Diane mentioned real briefly cybersecurity. I want to mention that too. She mentioned the three things the Department of Labor published: the tips for plan sponsors, the best practices, and then participant tips. When the government uses words like tips and best practices, that's a euphemism for we're going to put you in jail if you don't do this. So take that seriously. The reason you want to take that seriously is you may have read news reports about people breaching the security of asset custodians and impersonating participants or stealing the money or ransomware attack. All of that is a fiduciary issue. Who is responsible when that happens? Who pays to fix those problems? The custodian, the plan, the fiduciary. Should have brought some swag so I can induce some responses.
I don't know. Tell me, John, tell me.
The short answer is the fiduciary is responsible for that. The fiduciary is going to say, wait a second. Fidelity got hacked, not me. Why is this my problem? Well, because you're the fiduciary. You run the plan. You picked Fidelity. You have a service agreement with Fidelity. What does the service agreement say will happen if there's a ransomware attack? Oh, you didn't think about that? Well, that's not prudent. You should have thought of that when you entered into that service agreement. So a couple of things. One is you want to download those and look at those. They're easy. They're not written technically. They're written for people that are running plans that don't have, law degrees or whatever to understand that. The second thing you want to do is after you've read through those, you want to pull out your service agreements and look for things like what sort of indemnity rights do we have? If there's a screw up with this service provider, what's their obligation to make it right? Is there any obligation to make it right? What's our obligation? What sort of audit rights do we have where we can walk in and say, I want to see what your security plans are. I need to know that my money is safe with you. I want to be able to audit your processes and hardware and software systems designed to protect that because I'm the fiduciary that's responsible. Do you have the right to do that? What if you walk in and ask them and they say, we're not going to tell you that? What about liability caps? It's common in service provider agreements to have a liability cap where the service provider says, look, if we steal all of your money and treat you like crap, you can sue us only for the amount that you've paid us in the prior 12 months. That's a common provision that I see that I always remove. But you want to see, again, what's the maximum amount of exposure that carrier has? And then let's say that it's, oh, we'll pay for whatever it is. You want to say, well, how much money do you have? Because the promise is only as good as your bank account. Oh, you don't have a big bank account because you're an 8-man shop. Well, maybe we want to impose an obligation on you to have insurance coverage of minimum amounts from carriers with minimum ratings so that there's going to be somebody around to pay to fix the problem that might come up. All those things, like that, that's being a fiduciary. Those are all fiduciary things you should be thinking about after you've read the DOL guidance and gone back to look at all of your service provider agreements, TPA, record keeper, custodian, investment advisor, whoever it is. You want to make sure that there are provisions and they're addressing those sort of risk factors to protect your participants and you, because remember, what happens if there's a fiduciary breach? Who pays? Fiduciary pays. That means you want to make sure that you have insurance protecting you as a fiduciary. I know how it works. The CFO comes up to you and says, hey, HR person, you know a lot about the plan. Why don't you start running the plan? And you say, great, yeah, sure. I've gone to a lot of SHRM things. I'm pretty knowledgeable about this sort of stuff. And suddenly you realize that you're betting your house and your bank account on how the plan is being run. And maybe that's not a good idea. So make sure that you have insurance as well. Okay, now we're on to the updates. When do I end?
So you got about 5 minutes before you open the questions.
Okay,
Yeah.
okay. I'm on track. I'm going to zip through these quick. Diane mentioned that Secure 2.0 has passed the House. It's in the Senate. There is room. It's because of how the Senate passes things, it takes a long time. Today is the 7th of December. People would be going home for the holidays before Christmas. We have about maybe 10 days, 12 days to get that passed if it's going to be effective this year. There is support for that, but there is opposition as well. Some political. We don't want to give the Democrats a win. If you're a Republican, the Democrats are saying we don't want to look like we're going to be, anyway. It's likely to pass, but I don't know when. If it gets kicked into next year when we have a Republican House majority, does that change? I don't know. That's beyond my pay grade to figure out. The IRS issued new required minimum distribution regulations that are effective basically for distributions occurring next year. And because there were some surprises in those regulations, they also gave us some relief about 2020 and 2021 required minimum distributions. The change was that it used to be you had to take your money out in no later than 5 years. Remember this? You took it out ratably, or you could take it out as a lump sum no later than 5 years. The Secure Act changed that to 10 years, just swapped out 5 for 10. Everybody thought, well, you now have 10 years. The IRS regulations came out and said, nope, you have to take it out ratably through the years 1 through 9, then take the remainder out in year 10. And that was a surprise. Every estate planner in America said that's not what the statute said. That's what the regulation says. Because they didn't issue those regulations until 2022, people are saying, I've already taken, I didn't take a 2021 RMD. I didn't think I needed to. And so they gave relief for 2021 and 2022 required minimum distributions. Do any of you participate in MEPs, multiple employer plans? Okay, becoming a thing. There are rules, the IRS has issued rules about how they're going to work. In some instances, those work pretty well. You might want to think about that. They can offer access to lower cost investments, cheaper administration, per head administration costs, et cetera, if it's a good fit for you. The physical presence requirement, when you want to make distributions and you need spousal consent, what's the requirement? Notarized or in the presence of a plan administrator, right? One of those two things. Well, then COVID came. What do? We're not supposed to be face to face. And so the IRS said, well, you can do it over Zoom. You have a Zoom call where the person holds up their driver's license, compares the picture, the notary public or the plan administrator can compare the pictures, then they can watch them sign the document, and that'll be we'll do that. The rules that allow that expire 12/31. Unclear whether they're going to be extended. A lot of people have supported those rules, saying it's a great idea. Let's get into the 21st century here, use video technology. We don't need two people in the same room at the same time. Why don't we just, have a Zoom call and solve the problem? Don't know if that's going to happen. The lifetime income disclosures, your participant statements now should have an additional couple paragraphs that talk about what their lump sum benefit would be worth on a monthly basis. The idea is that nobody knows, if you tell a participant you've got 150 grand, they think, wow, I'm rich. But over a 20-year life expectancy, maybe not so much. And so the government said, well, what we want you to do is put on your participant statements how much of that, if you amortized out 150 over their expected life expectancy, how much is that per month? And so again, if your statements aren't doing that, you need to talk to your custodians. Finally, the 408B2 fee disclosures from welfare plan service providers. You've been getting those for retirement plan service providers for years. Now your welfare, health insurance, other welfare benefit plan providers also need to be giving you fee disclosures. If you're not asking for them, remember under the retirement plan, you have to ask, they either give them to you, then you ask, they have so many days to respond. If they don't respond, you're supposed to fire them because you're not in compliance with the rules. Same thing now with welfare plans. Exactly the same rules, exactly the same definitions. Couple of cases I want to mention quickly. Anybody work with pension plans? That's a hot area of litigation because a lot of pension plans are still using life expectancy tables created in the 1970s. Are people living longer now than they used to? Yeah, the answer to that is yes. And using a 1970s life expectancy understates a benefit you would owe them. And so a lot of this is the new class action target. If you have a large pension plan, it would not surprise me if some plaintiff's lawyer on behalf of some participant says, I want to see the mortality tables you're using. And if the number, those tend to be like GAM 74, general annuity mortality, 1974. When that plaintiff's lawyer sees that, that's a class action because he's going to win that case. Plan expenses, those are still ongoing class actions saying you're charging participants too much. The investment fees are too high. You're not exercising your fiduciary responsibility to be prudent and reduce those fees. Mandatory arbitration is a big deal. Can you force participants into mandatory arbitration? Short answer is you might be able to do that. If it's in the plan document, you probably can. Do you want to do that? There are pluses and minuses. What about state law mandates? We've seen a lot of those. States are setting up their own retirement plans, some of which are mandatory. Most of those have survived, at least at trial level, preemption challenges. And then Hughes versus Northwestern. Just want to mention that case because it was interesting. Guess how many investment options the Northwestern University is an elite academic school. You think it'd be run by smart people. So guess how many investment options their plan had?
Hundreds, right?
428. The reason it had 428 is the fiduciaries, the plan said, well, hey, it's too hard figuring out what's a prudent option and what's not. So we're just gonna put in everything. And then when we get sued, we're gonna say, well, we have all kinds of prudent investment options in there someplace. Of course, you can make a prudent, you participants can make good investment decisions, because out of 428 plans, how can you miss not getting some good ones? Supreme Court said that's not how fiduciary liability works. You're responsible for all those plans in there. If some of them are dogs, you're responsible for that. You can't do that. So if any of you are taking that tack that, well, hey, we've got 87 investment options and at least some of them ought to be good, right? You don't, that argument has now been tried and lost at the Supreme Court level. Well, time for questions. We've got 2 minutes,
Couple minutes, yeah.
couple minutes, ask away. Nothing, that surprises me. It's free legal advice, people. I can't tell you, every party I go to, somebody wants to know something legal. This is the first time this has ever happened.
Nice pictures there, John. Real nice.
Well, if you work up courage later, I will be hanging around. I'm happy to talk to you privately about anything you want. Thank you very much for your time. I think we're taking a 5-minute break.
Yep.
Take a 5-minute break, go out, get something to eat, stretch your legs, and thank you for coming.